Mr. Kimori does not appear in petition.
Okay. Petition number 1. Yes, Mr. Ochoki for the petitioner.
Yes.
There is Mr. Kali.
All is brief on this.
Calling brief
On this.
Mr. Nyamira for first and second.
Yes.
Then there is Mr. Nyamira for respondents. Okay. This is the ruling. I will not read the entire ruling. I will only read selectively from paragraph 4, where I say the issues for determination are therefore as follows: whether the admissibility of evidence can be addressed at this stage; B, whether the petitioner complied with rules 8(1)(c), 12(2)(e), 12(3), and 12(4) of the elections, parliamentary and county elections petition rules 2017, and 3, what is the effect of non-compliance, if any. The issue of admissibility of evidence, in my view, ought to be addressed when the party intending to rely on it has called a witness to adduce it. It is at this point when opposition may be voiced. I therefore find that it is premature to seek the court's intervention at this juncture. I'll not read what Rule 8 says and Rule 5 what it says. You all know. I'll only cite what Raila Odinga and others versus Independent Electoral and Boundaries Commission and 3 others. This is Nairobi Petition number 5 of 2013, where the Supreme Court said as follows: in the circumstances of the said case, no injustice had been or would be occasioned by failure by the petitioner to set out the results of the election. The fact that election disputes are sui generis, governed by a special regime of rules, does not exonerate the court of the prime obligation and indeed reason for its existence, that of delivering substantive justice. Went on to emphasize the effect of non-compliance with procedures. Our attention has repeatedly been drawn to the provisions of the Constitution which obliges a court of law to administer justice without undue regard to procedural technicalities. The article simply means that courts of law should not pay attention to procedural requirements at the expense of substantive justice. It was never meant to oust the obligation of litigants to comply with procedural imperatives as they seek justice from the court of law. This was well put, and I have nothing else to add. In the case of Washington, the Court of Review versus Independent Electoral Boundaries Commission, 2017 EKLR, the court was confronted with similar issues of non-compliance. When dismissing an application to strike out the petition for non-compliance, Esther Minor J said the following: the results of this election are therefore on the record. They are also known to the third respondent and his advocates fear that there will be no results to compare the evidence which has been put to rest. In addition, it is by finding that the third respondent has in no way been prejudiced, as even before bringing this application, he had filed his response and evidence, meaning that he very well understood the case physically. It was also argued that as the petition cannot be amended, the only solution is to strike it out. While I agree that the rules would not allow amendment of this petition so as to remedy the omission, it is by finding that in itself is not reason enough to strike out a petition. The results now form part of the record of the petition, and an amendment of the petition will not be necessary. Unquote. And I say, I don't agree with this reasoning. The Court of Appeal in the case of Nicholas Kitoara Kore versus IBC emphasized the same, and I'll quote in part, and they said it's globally established that where a procedural infraction causes no injustice by way of injurious prejudice to a person, such infraction should not have an invalidating effect. Justice must not be sacrificed on the altar of strict adherence to provisions of procedural law, which at times create hardship and unfairness. From the foregoing, therefore, unquote, from the foregoing, therefore, the application to strike out the petition is dismissed. Court will abide with the outcome of the petition. That is number one. Let's go to number three. For the petitioner, Mr. Kemosi, and you are today. You are for the first and second. Yes. You are not. Yes, I'm not. Mr. Kemosi. Then we have Ms. Mwai and Kaba.
Yes.
Okay. There's Miss Mwai.
Yes, Miss Mwai. Being assisted by Mr. Nyaberi.
Mr. Nyaberi.
Mr. Bukua.
Ole kidogo. Mr. Bukua.
And Mr. Omoyo.
And Mr. Omoyo.
Miss.
Oh.
Miss
Miss.
Omoyo.
Oh, sorry.
I'm present.
Sorry for calling you Mr. Mr. Omoyo. For third response.
My Lord, we also holding brief for Mr. Wamboi and Mr. Suma. They are joining us.
Wamboi
and Mr. Suma for the third respondent.
Hiyo ni battery yako tu. Okay. Sawa. Okay. Okay, this is the ruling. Again, I will selectively read without reading everything, but selectively in a way that will communicate what I'm saying. I'll read from paragraph 5, where security for costs is provided for under Section 78 of the Elections Act. It states, petitioner shall deposit security for the payment of costs that may become payable by the petitioner not more than 10 days after presentation of the petition under this part. The person who presents a petition, that is subsection 2, to challenge an election shall deposit 1 million shillings in case of petition against presidential, that is not our case, 500,000 shillings in case of petition against a member of parliament or a county governor, or I don't need to read the other bit because it's not relevant to us. I've also cited Rule 13.1, which I'm not going to read verbatim, and go to paragraph 7. The petition hearing was filed in court on 7 September 2022. The petitioner has exhibited a copy of official receipt marked EN01. The deposit was made on 16th of September 2022. This is therefore within the stipulated time frame. This issue cannot be the basis of striking out a petition. Then I'll skip paragraph 8, 9, because these are only citing the mode, but I think let me read Article 87 because it's important, because the mode of service is prescribed therein. It states, service of a petition may be direct or by advertisement in a newspaper with national circulation. In the case of, the third respondent applicant has contended that he was not served. In the case of Rosa Akini Buyu versus IBC and the 2 others, this is Kisumu Civil Appeal number 40 of 2013. The Court of Appeal said as follows: service of the petition upon respondent was a fundamental step in the electoral process and resolution of disputes arising therefore. Failure to serve the petition upon the respondents went to the root of the petition, and the petition could not stand when there was failure to serve the same. The CCTV footage produced by Mr. Hon.Kemosi, who testified on 4th November 2022, covered only one lobby. He said this was the main lobby. The footage was for the 21st September 2022 and ran from 3:54 p.m. to 12 p.m. Neither the third respondent nor the process server was seen in the footage in respect of this lobby. We can therefore say with certainty that if the process server and the respondent met at the Safari Park Hotel, then it could not have been in the main lobby. Walter Lando was the process server. He contended that he personally served the third respondent at the Safari Park Hotel, where the newly elected MPs were being inducted. He deponed and reiterated while being cross-examined that he called the third respondent from his phone number 0702 447 712. He called the third respondent's number 0727 654 220. This phone number does not appear on the call log supplied to the third respondent by Safari. He did not produce any other call log to counter the one produced by the third respondent. The process server is seen in a CCTV footage on 22nd September 2022 with a blue cover document which he left at the offices of Messrs. Mogaka and Company Advocates. He took less than a minute before leaving the document. He did not convince the court that he was marketing his auctioneering business. It was admitted that the last respondent was previously working in that office. This can therefore be concluded to be an attempt to serve him with the petition. This is not personal service, and this is by the petition. I am persuaded to believe there was no service for the last respondent, and the same is served in the manner contented by the process server, the court ought have indicated. I agree with the opinion expressed by Judge D.S. Kajanja in the case of Patrick Kigeta Kimanzi versus Marcus Miguel Mulubi, EKLR, where he said, although the regime of service of election petitions has been liberalized, the requirement of service was not dispensed with. Service of the petition is still a requirement under the Constitution, the Act, and the rules. Without service, the opposite party is denied the opportunity to defend the case. Service is an integral element of the fundamental right to a fair hearing, which is underpinned by the well-worn rules of natural justice. As a component of due process, it is important that a party has a reasonable opportunity to know the basis of allegations against it. Elementary justice demands that a person be given full information on the case against him and given reasonable opportunity to present a response. I therefore find that this petition lacks the basis to stand on for non-service. I accordingly strike it out in justice.
Good.
Okay, let's go to petition number 1 for trial.